In this session, we will see about the doctrine of indoor management and constructive notice in Article of Association Companies Act. First, we will see the constructive notice. What is constructive notice? That is, the law presumes that the person dealing with the company has seen the Article of Association, he has read it and he has understood it properly. The reason behind this is the Article of Association is filed with the Registrar of Companies. At the time of incorporation itself, it is filed. Subsequent alterations are also filed with the Registrar of Company. Registrar of Company is a public office. These documents are categorized as a public document. Anyone can go and see the documents. So, the person, before dealing with the company, has to go to the Registrar of Company and see the articles, whether the person who is going to deal with has a power to deal on behalf of the company. It is applicable not only to the Article of Association, it is applicable to the Memorandum of Association and the Special Resolution, because they are also filed with the Registrar of Company and categorized as public documents. But this will not applicable for the returns filed or financial statements. So, the doctrine of constructive notice is anybody dealing with the company has seen the Article of Association, read it and understood it properly. There is a case, Kotla Venkatasamy versus Chinna Ramurthy. As per the Article of Association, 3 persons has to execute the mortgage deed. One managing director, working director and the secretary. But actually 2 persons signed. Only the working director and the secretary signed. Managing director did not sign. The court held that the document is a mortgage deed is not valid because it is not signed by the mortgage managing director. The person dealing with the company should have seen the Article of Association where it is written that the document should be signed by 3 persons. It is your mistake, you are not seeing the Article of Association. Doctrine of constructive notice is there. We presume that you have seen, so the document is not valid. But this doctrine has losing its importance, diluted. But in English it is already repealed. Section 35A Companies Act of 1989 it is repealed. But in India also this importance is not that much. Even in one case, Dehradun Mussoorie Electric Tramway Company versus Jakhmandar Das. In this case, another person signed as a attorney of a director, even then the court held the company is liable. So, this is about constructive notice, doctrine of constructive notice. Everybody dealing with the company is presumed to have seen the Article of Association and understood in the proper sense. Now we will move on to the indoor management. Indoor management means a person cannot go into the company and see whether the preliminary things, procedural things required for the Article of Association has been done. In constructive notice, we are seeing that we should see that Article of Association is there, the concerned person is properly given power to deal with the other person. For example, the Article of Association says the Board of Directors can nominate 2 persons to sign the document. Board of Director. In that case, the Board of Directors has to pass a resolution. We don't have access to the Board of Directors meeting minutes book. We cannot see that. We can presume that the Board of Directors has passed the resolution and the 2 persons has come for signing. This doctrine of indoor management means that everybody has to go by the Article of Association. Everybody dealing with the company has to see the article and see that the provisions in the Article of Association are abide by the provisions. But the preliminary things, procedural things need not be seen because we have no access to the company's books, records. This concept was started, this doctrine, in 1856 in a case Royal British Bank versus Turquoise. It is also called as a Turquoise rule. In this case, the company directors issued borrowed money, but the issue of bonds requires a resolution. The shareholders contended that no resolution is passed, so they are not liable under the contract for the money borrowed. But the court held, you have the power, the borrowing power is with the directors. This person has a right to presume that the directors have got the power by passing a resolution from the shareholders. It is your internal thing. Passing a resolution, authorizing is internal. According to the article of association, the borrowing can be done by the directors. That is why this person has given money. Your company is liable. The rule is provisions of the articles should be abided by the terms. The person has to see and see that, ensure that it is according to the provisions of article association. He need not go beyond the article of association to see that the procedural things, the preliminary things required for the article of association is complied with. What are the reasons? There are two reasons. One thing, the person dealing with the company has no access to the company books. We cannot see whether the company has passed a resolution or procedural things. We cannot see. One thing. Second, if permitted, the company will say that, quote some procedural lapses and say that we are not liable. The directors might have borrowed, then the shareholders will say it is not according to the resolution passed by us, so it is not liable. So company may escape liability. For that, this doctrine of indoor management has come. If it is according to the provisions of the article of association, the person dealing with the company can opt on that. He need not verify the procedural preliminary things to be done by the company, which is an indoor management of the company. Now we will see some exceptions on that. This is not a defense for all cases. When a person knows that irregularity, then he cannot say a doctrine of indoor management. In one case, marriage versus consent. In this case, it's an allotment of share. This person was inside a meeting room. He knows that it is irregular. Then he cannot put the defense of indoor management when he knows the irregularity. Second, when there is a suspicion of irregularity, then also doctrine of indoor management will not come. For example, a person, accountant, signed the sale deed. There is a suspicion. Normally, director or managing director will execute. But here the accountant is executing the sale deed. There is a suspicion. So, in that case also, doctrine of indoor management will not come. Third is forgery. In case of forgery, doctrine of indoor management cannot be claimed, because it is a forgery which makes the document as a invalid document. One case, Reuben versus Great Fingale Consolidated. In this case, company secretary affixed the seal of the company and forged the director's signatures. It was held that company is not liable because it is a forgery. But in another case, in Madras case at High Court, official liquidator versus Commissioner of Police. Here the managing director forged the two directors' signature. But the court held the company is liable. For the reason the managing director is the agent of the company, he acts within his scope of the authority, and during that he has done the forgery work. Managing director, so the company is liable because managing director is the agent of the company. That is why it is company is liable. Fourth, representation through articles. If the articles gives a delegation of powers to somebody, we can presume that the person has the authority. In one case, British Thomson Houston Company Limited versus Federated European Bank Limited. One director came and signed as NP, and he has executed the documents. Subsequently, the company is claiming no resolution is passed. The court held there is a provision, the directors are having the power. We need not see whether the resolution is there or not. You can presume that there is a delegation of authority. Next is scope of authority. If it is within the scope of authority, we can presume that the person has the authority to execute. This is an interesting case to Muhammad versus Rawat Bombay House. In this case, the article provides the agreement should be signed by two persons unless otherwise provided by another resolution. That is, the agreement can be signed by two persons. If one person has to sign, then a resolution is required. But one person came and executed the documents, promissory notes. The company was putting a defense, it is not valid because two person has not signed. Court held this person has a right to presume that the resolution is passed. That is why he has taken one signature. The company is liable. Another one acts outside apparent authority. On seeing itself, we say that this person has no right. Already we have seen the example, the accountant executing a sale deed. In that case, it is an apparent authority. Seeing itself, we can say this is not within his authority. In that case also, doctrine of indoor management will not come. Next session, we will see another topic.